Hi, this is Rex Crandell, and we're going to be talking about godparents and godchildren today. And this is part of an estate planning series. Oftentimes, I hear people say, I'm got to do something with my goddaughter or godson. And I think too often there's an implication when somebody agrees to step in as a godparent that the parent of the child thinks that that person is going to raise the child if the parents pass away. So, looking at that concept, I put together some material to be able to dissect it from more of a legal standpoint and more with the goal to make it more effective for both the parents, the children, and the godparents. So, what is a godparent? A godparent in Christianity is one who stands in surety for another in the rite of baptism. So, child's being baptized, the godparents are there, and it's a religious rite. In the modern baptism, an infant or child of the godparent or godparents makes a profession of faith for the person being baptized, the godchild, and assume that obligation to serve as proxies for the parents if the parents are either unable or neglect to provide the religious training for that child in fulfillment of the baptismal promises. So the original agreement to be a godparent is not based on what can happen is that raise the child. Many people use a concept to imply that the godparent will act as a guardian and raise the child if both parents die. Moral obligations and good intentions aside, a verbal agreement to raise a child in the parent's absence is not valid for any legal purposes. So there's no obligation, in fact. What happens if the godchild parents die and the godchild is in the hospital and needs immediate medical care? Well, the godparent can do nothing. The godparent is blocked by the HIPAA laws that medical personnel cannot talk to any third party not authorized by a document by the parent. So it becomes a problem. The parent should have prepared an advanced health care directive for the godchild when the parents were healthy. The godchild should have been named as the health care agent for the godchild in a validly executed advanced health care directive that takes care of one problem. What happens if both parents are deceased and the godparents do want to raise the godchild? The proper legal method should be to nominate a proposed guardian in the last will and testament of both of the parents. And a judge will likely follow that nomination in a will when a godchild is brought before the guardianship proceedings for the godparent to obtain a guardian of the person. If no legal document exists naming the proposed guardian, then any family member, third parties with legitimate interest in the child and the child's upbringing can petition the court to be the guardian. And sometimes this causes legal disputes. So if you're planning on raising a child in as a guardian or as a godparent, it is suggested that you talk to the parents, have them fill out an advanced healthcare directive for the child, and also name you as nominee in their wills. So that's the best way to handle it. And it's better to put a document in writing rather than just rely on what I think most people do, and that is just hope that the person takes over and does that. This method gives you a lot more legal authority. So it's a better way to do it. And if you have any questions, you can contact our office.